The email arrived at 7:23 a.m. on a Wednesday. I was 3 weeks into medical leave recovering from surgery, checking my personal email over breakfast when I saw the subject line, "Return to work discussion, urgent response required." Sender, Bethany Morrison, HR Director. I opened it. The message was brief and deliberately vague. "Claire, we need to discuss your continued absence and return to work timeline. Please schedule a meeting with HR this week to review your status and provide updated medical documentation." This is time sensitive. I'd been on approved medical leave. I'd submitted all required FMLA paperwork before my surgery. My doctor had cleared me for 6 weeks of recovery. I was 3 weeks in, healing on schedule, doing exactly what my medical team had told me to do. And HR was calling my absence continued like it was unauthorized and demanding an urgent meeting like I'd done something wrong. I forwarded the email to my husband, Marcus, who was in the kitchen making coffee. "Does this seem weird to you?" He read it on his phone. "Weird and aggressive. You're on approved leave. Why would they need to discuss as anything? That's what I'm wondering. Don't respond yet. Call your doctor's office and make sure all the paperwork is in order. Then call the company and verify your leave status." Marcus worked in employment law, not as an attorney, but as a paralegal for a firm that specialized in workplace discrimination and FMLA violations. He'd seen enough HR departments try to pressure employees during medical leave to recognize the warning signs. I spent the morning making calls. My doctor's office confirmed they'd sent all required documentation to my employer, including the initial certification and the 6-week recovery timeline. The company's leave management system showed my leave as approved with an expected return date 3 weeks away. Everything was properly documented and approved. So why was HR acting like I needed to urgently explain myself? I called Marcus at lunch. "Everything checks out. Leave is approved. Documentation is submitted. Return date is clear. So what's this email about? Sounds like they're either trying to pressure you back early or they're building a case to claim you abandoned your position. Either way, don't go to that meeting alone." "What do you mean, don't go alone? HR doesn't call urgent meetings about approved leave unless something's wrong. If you meet with them, bring documentation and consider having someone present. Actually, you know what? Let me talk to one of the attorneys at my firm. This feels like something they'd want to know about." "Marcus, I don't want to make this a legal issue. Maybe it's just a miscommunication." "Maybe. But in my experience, when HR uses language like urgent response required for approved medical leave, it's not a miscommunication. It's a setup. Let me make a call." That afternoon, Marcus connected me with Elena Rodriguez, a senior attorney at his firm who specialized in FMLA cases. I explained the situation: approved leave, proper documentation, sudden urgent request to meet and discuss my status. Elena listened without interrupting, then said, "Claire, I've seen this pattern before. The company needs to fill your position or they're unhappy about the leave timing, so they try to create pressure for you to return early or resign. The vague language about reviewing your statuses is designed to make you feel like your job is at risk without explicitly threatening you. Can they do that? No. FMLA protects your job during approved medical leave. But companies try to work around it by claiming the leave wasn't properly documented, or that you're not responding to reasonable requests for updates, or that business needs require restructuring your position. It's all pretexts, but employees often don't know their rights well enough to push back. So what should I do? First, don't meet with HR without representation. You have the right to have someone present. Second, I'm going to send a letter to your company on your behalf, making it clear that you're represented by counsel and that any further communication about your leave should go through me. Third, document everything from this point forward. Every email, every call, every attempt they make to contact you. Won't sending a lawyer letter make things worse? Make them think I'm being difficult? They already think you're being difficult by taking the medical leave you're legally entitled to. The lawyer letter doesn't make it worse. It makes it clear that they can't intimidate you into doing something that violates your rights. Most companies back off immediately once they realize an employee knows the law and has representation. Okay. Send the letter. Elena drafted it that afternoon. It was professionally worded but direct. I was represented by counsel, My medical leave was properly approved under FMLA. Any questions about my leave or return to work should be directed to her office, and any attempts to contact me directly about employment matters during my medical leave would be considered interference with protected leave. She sent it to Bethany Morrison in HR, CCing the company's general counsel and my direct manager, Neil Patterson. The response came within 2 hours. Not from Bethany, but from the company's general counsel, David Huang. Ms. Rodriguez, we received your letter regarding Claire Hendricks. Please be advised that Ms. Hendricks' leave is properly approved, and there is no question about her status or return date. The HR communication was routine follow-up and not intended to create any pressure regarding her leave. We apologize if the message was misinterpreted. Elena forwarded it to me with a note. Translation: they were testing to see if you knew your rights. When they realized you have representation, they immediately backed down and claimed it was all a misunderstanding. This confirms they were planning something inappropriate. I felt vindicated and angry at the same time. If I hadn't had Marcus's experience to recognize the warning signs, if I hadn't had access to an attorney through his firm, I might have gone to that urgent meeting and been pressured into returning early or signing something that waived my rights. Before I tell you what happened next, I need you to understand something about this moment. This wasn't about a single questionable email. This was about a company testing whether they could violate federal law if the employee didn't know enough to stop them. And it was about what happens when you do know your rights and have someone willing to enforce them. If you've ever been pressured to return from medical leave early, if you've ever had HR question your doctor's orders, if you've ever felt like taking legally protected time off was somehow being held against you, stay with me. Because what my company learned was that FMLA exists for a reason, and employees who know their rights can't be bullied into giving them up. My name is Claire Hendricks, and I'd been a senior project manager at Vertex Solutions for 5 years. We're a consulting firm, about 250 employees, providing business strategy and implementation services for mid-sized companies. I was good at my job. Consistently high performance reviews, strong client relationships, successful project deliveries. I managed complex engagements that required coordinating multiple work streams and keeping clients happy through difficult organizational changes. The problem started 2 months before my surgery, when I'd been assigned to lead the Paramount Industries engagement, a major account that represented about $3.20 million annual revenue. The project was scheduled to run through Q4 and into Q1 of the following year. Around the same time, I'd been diagnosed with a condition that required surgery. Not emergency surgery, but medically necessary within a reasonable time frame. My doctor recommended scheduling it sooner rather than later, and after discussing with my surgeon, we'd set a date in mid-September. When I'd informed Neil Patterson, my manager, about the surgery and requested FMLA leave, his reaction had been less than supportive. Claire, the timing is really difficult. You're leading Paramount, and we're at a critical phase. Can you push the surgery to after the holidays? My doctor doesn't recommend waiting that long. How long will you be out? 6 weeks for full recovery. 6 weeks? That's impossible. The Paramount project needs you. Can you do 3 weeks? Neil, this is what my doctor is recommending for the type of surgery I'm having. It's not negotiable based on project timelines. I'm not saying don't have the surgery. I'm saying think about the timing. Maybe there's a way to schedule it that's less disruptive to the business. I've already coordinated with my surgeon. The date is set, and legally I'm entitled to FMLA leave for a serious health condition. I'm not asking permission. I'm notifying you of my medical leave as required. Neil's expression had shifted, not overtly hostile, just cold. Fine. Submit your FMLA paperwork, but understand that this is going to impact the team and the client. We'll need to make adjustments. I'd submitted all the required paperwork. FMLA certification from my doctor. Leave request through the company portal. Documentation to our third-party leave administrator. Everything was approved within a week. I'd also spent 2 weeks before my surgery preparing for my absence. I'd created detailed project documentation, briefed my backup manager, communicated with the client about the temporary transition, and ensured everything was in good shape for the team to continue without me. Then, I had my surgery. started my recovery, and focused on healing. Until the email from HR 3 weeks later, questioning my continued absence. After Elena's letter and the company's quick backtrack, I thought that would be the end of it. They'd tested me, I'd demonstrated I knew my rights, they'd backed off. I was wrong. Week 4 of my recovery, I got a call from Neil. Not an email, a call to my personal cell phone at 8:15 a.m. on a Tuesday. Claire, hi, Eamon. How are you feeling? I'm recovering well, thanks. Good, good. Listen, I wanted to check in about Paramount. The client has been asking about you, wondering when you'll be back. They're concerned about continuity. I communicated with them before my surgery about the timeline. They knew I'd be out for 6 weeks. Right, but they're getting anxious. And honestly, the backup manager is struggling with some of the relationship dynamics. You know how demanding the Paramount team can be. Is there any chance you could come back a bit early? Even part-time? Neil, I'm on medical leave. I can't work during FMLA leave. That's the law. I'm not asking you to work. I'm asking if you feel well enough to return early. If your doctor clears you. My doctor has me on a 6-week recovery timeline. I'm 4 weeks in. Unless there's a medical reason to revise that timeline, I'm not going to ask him to clear me early just because a client is anxious. Claire, I need you to understand something. This is a critical account. If the client loses confidence and takes their business elsewhere, that's $320 million in revenue. Your position exists because we have accounts like Paramount. If we lose the account, we lose the justification for your role. There it was. The threat, dressed up as concern. Come back early from medical leave, or your job might not exist when you return. Neil, are you threatening to eliminate my position while I'm on FMLA leave? I'm not threatening anything. I'm explaining the business reality. Client relationships are fragile. When key people are unavailable, clients look for alternatives. That's just how it works. I'll let my attorney know about this conversation. Your attorney? Claire, there's no need to make this adversarial. I'm just trying to help you understand the situation. The situation is that I'm on federally protected medical leave, and you're calling me to pressure me to return early, and implying that my job might be eliminated if I don't. That's called FMLA interference and retaliation. And it's illegal. That's not what I'm doing. I'm going to hang up now. Any further communication about my leave or employment should go through my attorney. I ended the call and immediately called Elena Rodriguez. He did what? Elena's voice had gone from professional to angry. He called you. Directly, during medical leave, to pressure you to return early and threaten that your position might be eliminated? After we sent a letter specifically saying all communication should go through my office? Yes. Okay. This just escalated from potential FMLA violation to active, documented retaliation. I need you to write down everything you remember from that conversation while it's fresh. Exact words if possible. Time, date, what he said, what you said. Then I'm sending another letter. This one won't be polite. Elena's second letter was blunt. It outlined Neil's phone call, characterized it as clear FMLA interference and retaliation, noted that it violated the explicit instructions in her previous letter that all communication go through counsel, and indicated that we were documenting all violations for potential legal action if the pattern continued. She sent it to David Huang, the company's general counsel, with copies to the CEO and the head of HR. This time, the response took longer. 3 days. Then I got a call from David Huang directly. Ms. Hendricks, this is David Huang, Vertex's general counsel. I apologize for calling you directly, but I wanted to address the situation personally. May I speak with you, or would you prefer I coordinate through Ms. Rodriguez? You can speak with me if this is about resolving the situation. If it's about pressuring me further, I'll refer you to my attorney. It's about resolution. First, I want to apologize. Neil, Patterson's call to you was inappropriate and violated both company policy and FMLA regulations. He's been formally counseled, and there will be no further contact with you about work matters during your leave. Counseling? Not disciplined? I can't discuss specific personnel actions, but I can tell you that the company takes FMLA compliance seriously, and Neil's conduct has been addressed. What about his threat to eliminate my position? There's no plan to eliminate your position. Your role is secure. The Paramount account is being managed in your absence, and you'll resume your responsibilities when you return from leave. And if the client relationship has deteriorated by then, will I be blamed for that? No. Client management during your leave is not your responsibility. If there are relationship issues, they'll be addressed through appropriate channels that don't impact your employment status. I want that in writing. I'll send a confirmation letter today. Is there anything else you need to feel comfortable completing your recovery without work-related stress? Yes. I want assurance that when I return, I'm not walking into a hostile environment because I enforced my rights under FMLA. You have my word that retaliation of any kind won't be tolerated. If you experience any issues when you return, contact my office directly. I'll handle it personally. The confirmation letter arrived that afternoon. It reiterated everything David had said. My position was secure. No retaliation for taking FMLA leave. Neil had been counseled. Any concerns about a hostile environment should be reported directly to law. Elena reviewed it. This is good. They're covering their bases legally and making commitments they know could be used against them if they violate them. You're in a strong position. So what happens now? You finish your recovery. You return to work on your approved date. You document any retaliation or hostility. And if they violate any of these commitments, we have grounds for a lawsuit that they'll lose badly. The remaining 2 weeks of my leave were quiet. No calls from Neil. No urgent emails from HR. No requests for me to attend meetings or review materials. The company had learned that FMLA means leave, actual leave. Not working from home while pretending to recover. My first day back was a Monday, exactly 6 weeks after my surgery. I'd been cleared by my doctor, felt physically recovered, and was ready to return to work. But I was also nervous. Nervous about seeing Neil after our confrontation. Nervous about whether the Paramount account had fallen apart in my absence. Nervous about whether I'd face subtle retaliation despite the legal department's promises. I arrived at 8:30 a.m. My desk was exactly as I'd left it. My access badges worked. My computer login was active. Nothing had been changed or removed. At 9 a.m., I had a scheduled meeting with Neil. A return-to-work discussion that was standard protocol. After extended leave, I walked into his office with a notebook and a level of wariness I'd never felt before my surgery. Neil looked uncomfortable, which was appropriate given that he'd illegally pressured me during medical leave. "Claire, welcome back. How are you feeling?" "I'm fully recovered and cleared to return to full duties." "Good. I wanted to brief you on what happened while you were out. The Paramount account has had some challenges. Before we get into that, I want to address something. The phone call you made to me during my leave was inappropriate. You pressured me to return early, implied my position might be eliminated, and violated explicit instructions from my attorney that work communication should not occur during my FMLA leave. I've been counseled by a lawyer about that. It won't happen again. It shouldn't have happened the first time. FMLA exists to protect employees during medical leave. What you did wasn't just inappropriate, it was illegal. Do you understand that?" He nodded stiffly. "Yes. Going forward, if there are any issues with my performance or my role, they need to be addressed through proper channels, documented in writing, and not used as threats during protected leave. Clear? Clear? Good, good." Now what happened with Paramount? For the next 30 minutes, Neil walked me through the status of the Paramount account. The backup manager had struggled with some relationship dynamics, as Neil had predicted. But the client had remained engaged and the project was still on track. The challenges were fixable, not catastrophic. "So the client didn't leave," I said. "Despite your concerns that my absence would drive them away, they expressed frustration, but they stayed committed to the engagement because they were working with a competent backup manager and a professional team. My presence isn't the only thing holding the account together. That's what good project management structure looks like." After the meeting with Neil, I checked in with my team. They were genuinely glad to see me back, asked about my recovery, and brought me up to speed on project details. No hostility, no awkwardness about my leave, just normal colleagues welcoming back a team member who'd been out. Over the next few weeks, I rebuilt momentum on the Paramount account. The client relationship stabilized quickly. The backup manager had done solid work maintaining progress, and I was able to step back into leadership without major issues. But I also kept detailed documentation. Every interaction with Neil, every decision about the Paramount account, every communication that could potentially be framed as retaliation. Not because I expected problems, but because Elena had taught me that documentation protects you when problems arise. 3 months after my return, I got an unexpected email from David Huang, the general counsel. Claire, I wanted to follow up on your return to work experience. Have there been any issues or concerns about retaliation or a hostile environment? I replied honestly, no issues. Neil has been professional, the team has been supportive, and my work has returned to normal. Good. I also wanted you to know that we've implemented new training for all managers on FMLA compliance. What happened with your leave revealed gaps in our management understanding of protected leave rights. We're addressing that systematically. That's good to hear. May I ask what prompted this? You didn't have to implement company-wide training because of one incident. 2 reasons. First, it was the right thing to do. Second, our employment practices liability insurance requires us to demonstrate active compliance training when FMLA violations are identified. But honestly, even without the insurance requirement, we should have been doing this training already. I appreciate the honesty. I also want to acknowledge that you handled a difficult situation appropriately. You knew your rights, you obtained representation, you documented everything, and you didn't back down when pressured. That's not easy, especially when you're dealing with health issues and should be focused on recovery. I had help. My husband works in employment law and connected me with an attorney. Most employees don't have that advantage, which is exactly why we need better manager training. Employees shouldn't need lawyers to enforce their basic rights under federal law. Managers should be educated enough not to violate those rights in the first place. 6 months after my return, Vertex Solutions announced organizational changes. Neil Patterson was moving to a different role, pursuing new opportunities in business development, according to the announcement. His replacement as my manager was Sandra Kim, who'd been with the company for 12 years and had a reputation for being a strong advocate for her team. Her first meeting with me included a clear statement: I've been briefed on what happened during your medical leave. That's not how I operate. If you need leave, medical, family, whatever, take it. That's what FMLA exists for. Your job will be here when you get back. I didn't know if Neil's move was related to his FMLA violations or if it was coincidental. But I knew that having Sandra as my manager felt safer. A year after my medical leave, I was presenting at a women's leadership conference. The session was about knowing your workplace rights, and I'd been invited to share my experience. A year ago I took 6 weeks of FMLA leave for surgery. 3 weeks into my recovery, HR sent an urgent email demanding I meet to discuss my status, even though my leave was properly approved. Then my manager called to pressure me to return early and implied my position might be eliminated if I didn't. If I hadn't known my rights, if I hadn't had access to an attorney, I might have gone to that HR meeting unprepared and signed something waiving my protections. I might have returned to work before I was medically cleared and risked complications. I might have lost my job because I took legally protected leave. Here's what I learned. FMLA violations are common because companies bet that employees don't know their rights. They use vague, urgent language to create pressure. They imply that taking leave will have career consequences. They contact you during leave to blur the line between recovery and work. All of it is illegal, but it works if you don't know the law. So, here's my advice. First, if you're taking FMLA leave, document everything. Save all emails, note all phone calls, keep copies of medical certifications. Second, if your employer contacts you during leave to discuss work or pressure you to return early, that's interference. Get it in writing if possible. Third, if things feel wrong, consult an employment attorney immediately. Many offer free consultations. Fourth, don't be afraid to enforce your rights even if it makes you seem difficult. Protected leave exists for a reason. After the presentation, a woman in her 30s approached me. Ms. Hendricks, I'm going through something similar right now. I'm on medical leave for a chronic condition and my manager keeps texting me asking when I'll be back, saying the team needs me. Is that interference? Yes. Your manager shouldn't be contacting you during FMLA leave to discuss work or your return date. That's your medical team's decision, not theirs. Have me. You told them to stop contacting you? I feel like I can't. Like, if I push back, they'll find a way to eliminate my position. That fear is exactly what they're counting on. But here's the reality. If they eliminate your position during FMLA leave, or shortly after you return, and you've documented that they were pressuring you during leave, you have a retaliation claim. The law protects you, but only if you enforce your rights. How do I do that without a lawyer? I can't afford one. Start by sending an email to your manager and HR, stating that you're on FMLA leave, that work-related contact during leave is inappropriate, and that all questions about your return should be directed to your healthcare provider's timeline. Use the words FMLA leave and inappropriate contact explicitly. That creates a record. Then, if the contact continues, look for an employment attorney who works on contingency. They don't charge unless you win. Will that make things worse when I go back? It might make things uncomfortable. But staying silent while they violate your rights definitely makes things worse. The question is whether you want to protect yourself or protect them from consequences for illegal behavior. 2 years after my medical leave, I received a LinkedIn message from someone I didn't know. Hi Claire, my name is Jennifer Martinez. I work at Vertex Solutions in the Atlanta office. I recently took FMLA leave, and HR has been questioning my absence even though it's approved. Someone told me you went through something similar and might have advice. I called her. Jennifer, tell me what's happening. She described a pattern nearly identical to what I'd experienced. Approved FMLA leave, urgent emails from HR requesting meetings, manager implying her absence was creating problems, pressure to return early. Have you talked to David Huang in legal, our general counsel? No. I didn't think I could just contact legal directly. You can, especially when HR is potentially violating your FMLA rights. David told me to contact him directly if I ever experienced retaliation. I'm guessing that offer extends to other employees too. Call his office, explain what's happening, and reference the FMLA training the company implemented. He'll know what you're talking about. What if they retaliate against me for contacting legal? Then you document that retaliation, and you have an even stronger case. But, Jennifer, here's what I learned. Companies that violate FMLA rights do it because they think they can get away with it. The moment they realize an employee knows the law and will enforce it, they back down. Send an email to legal. Document everything. Don't be afraid to protect yourself. 3 years after my medical leave, Vertex Solutions was facing a lawsuit from another employee claiming FMLA retaliation. Not in my office, but in a different division. I wasn't involved, but I heard about it through company communications. David Huang reached out to me. Claire, we have a situation. An employee is claiming FMLA violations similar to what you experienced. Would you be willing to speak with our legal team about your experience? It would help us understand patterns and improve our practices. Is this to defend against the lawsuit or to actually fix problems? Both. We can't defend against valid claims. If we violated someone's rights, we need to acknowledge that and make it right. But we also need to understand where our systems are failing, so we can prevent future violations. I agreed to meet with the legal team. Spent 2 hours walking them through my experience. The initial email from HR, Neil's pressure call, the legal intervention, the resolution. At the end, one of the attorneys asked, what would have prevented this from happening to you? Better manager training before problems occur, not after. Clear communication that FMLA leave is protected and cannot be used against employees. HR systems that flag when managers are contacting employees during protected leave. And consequences for managers who violate FMLA rights that are significant enough to deter violations. Were you satisfied with how we resolved your situation? Eventually. But I shouldn't have needed a lawyer to enforce my basic rights under federal law. The fact that I did means your systems failed before my leave even started. The lawsuit eventually settled. I don't know the terms, but I know the company implemented additional FMLA protections after automated flags when managers contact employees during leave, mandatory legal review before any position changes for employees on or recently returned from FMLA leave, and strengthened whistleblower protect. IONS. If you've stayed with me through this entire story, I want you to understand something. This isn't about being confrontational or litigious. It's about knowing that your rights exist and being willing to enforce them when necessary. When HR questioned my medical leave, they were testing whether I knew the law. When my manager pressured me to return early, he was betting I'd comply rather than fight. When I obtained legal representation, they backed down immediately because they knew they'd been caught violating federal law. FMLA exists because without it, employers would force sick and injured employees to choose between their health and their jobs. But the law only protects you if you know it exists and you're willing to enforce it. If you're facing FMLA interference, if you're being pressured during medical leave, if you're worried about retaliation for taking protected time off, remember this. Document everything. Know your rights. Don't be afraid to get legal help. And don't back down when employers try to intimidate you into giving up protections you're entitled to. If this resonates with you, hit that like button and subscribe. Share your experiences in the comments about FMLA violations or times you had to enforce your workplace rights. Those stories help others recognize when they're being taken advantage of. Remember, HR questioned my medical leave, trying to intimidate me into returning early. I stayed calm, documented everything, and let legal handle it. The tone changed fast once they realized I knew my rights. And the company learned that FMLA isn't optional.